If you only remember one thing from this video, remember this. The first 60 seconds of an encounter with immigration officers can decide whether a situation stays calm and controlled or spirals into a search, an arrest, or a case that gets much harder to fix later. And a lot of people lose that first minute because they do not know one basic difference. An administrative warrant is not the same thing as a judicial warrant. Today, I am going to walk you through what is being reported and discussed as new 2026 guidance after recent ICE raids, what we can verify versus what is still unclear, and the exact words you can use to protect yourself and your family without escalating anything. By the end, you will know 1. How to check what kind of warrant they have. 2. What you can say and do at the door to protect your Fourth and Fifth Amendment rights. And 3. The one mistake people make that causes avoidable damage in the first minute. Before we get into the practical scripts, one quick note about accuracy. Your prompt mentions an urgent federal order and updated rights in 2026. Because viral clips and posts often summarize these events loosely, I am going to treat this as there are reported or discussed policy changes or court guidance in 2026, and there may be new emphasis in enforcement operations. I cannot confirm a specific official order or its exact wording based only on what you provided. So I will separate what is generally true under U.S. constitutional law and common immigration enforcement practice from anything that would require a specific memo, executive order, or court ruling. The constitutional basics do not change overnight, and that is good news for you. Now, what changed? In plain English. When people hear there was an order after raids, they usually think it means ICE can now do more, or your rights got weaker. But in practice, what often changes is operational guidance, how officers approach homes, how they document contacts, what they prioritize, and how local cooperation or court interpretations affect encounters. Your rights at the door still hinge on the same core issues. Do officers have legal authority to enter? Do you consent? And what you say or sign. Here is the part most people miss. Officers may lawfully ask you questions even when you do not have to answer them, and the pressure of the moment makes people volunteer information or permission they were not required to give. So let us define the two warrants fast. A judicial warrant is issued by a judge or magistrate. It is the kind of warrant most people think of in criminal cases. It typically allows entry or a search if it is a search warrant, and it will usually have a court name, judge signature, and specific details. The key point is that it comes from a court. An administrative warrant, in the immigration context, is generally an ICE or DHS document signed by an immigration official, not a judge. You may hear forms referenced in conversations, but you do not need to memorize form numbers to protect yourself. The key point is that an administrative warrant is not the same as a court-issued warrant. That difference matters most at your home. At your home, the baseline rule is simple. If officers do not have a judicial warrant, they generally need your consent to come inside. And if you let them in, many of the protections you thought you had become harder to use. This is why the door is the entire game. Here is a bridge hook you should hold on to. You can be respectful, calm, and cooperative without giving up your rights. The goal is not to argue. The goal is to slow the situation down, verify what is happening, and avoid accidental consent. Let us talk about who is affected most. If you live in a mixed status household, meaning some people are citizens or green card holders and some are not, you are high priority for preparing because confusion at the door is common. If you live with roommates, extended family, or in multi-unit buildings where people share entrances, you also need a plan, because officers can use normal human mistakes to get inside. Someone panics. Someone opens wide. Someone says yes without thinking. If you are a senior in the home, or you have children who might open the door, preparation matters even more because officers may rely on whoever answers. Now, who is usually not the target in a home raid-style operation? Many lawful permanent residents, U.S. citizens, and people with no criminal record are not the stated focus of targeted enforcement. But here is the important caution. Being not the target does not mean you cannot be impacted. Collateral consequences are real. Someone else in the home might be the target. Officers might be looking for a person at an old address, or your name might be similar to someone else. Also, even lawful status does not eliminate risk if you end up consenting to searches, producing documents you do not understand, or making inconsistent statements. Myth versus reality number 1. Myth. If ICE knocks, you have to open the door. Reality. You generally do not have to open the door unless they have a judicial warrant that authorizes entry. You can communicate through the door. You can ask them to show the warrant. You can ask them to slide it under the door or hold it up to a window. You can take a photo if safe. You can say you do not consent to entry. Myth versus reality number 2. Myth. If you stay silent, you look guilty and it will get worse. Reality. You have a constitutional right to remain silent. You can politely refuse to answer questions. Silence is not the same as resisting. The key is to stay calm and use the same short sentence again and again. Now let us get extremely practical. Here is a simple script for the door. Practice it. Write it down. Teach it to everyone in the home who might answer. Step 1. Do not open the door. Speak through the door. Say, "Hello, who are you and what agency are you with?" Step 2. Ask for identification. Say, "Please show your ID to the window or camera." Step 3. Ask for the warrant. Say, "Do you have a judicial warrant signed by a judge? Please hold it up to the window or slide it under the door." Step 4. If it is not a judicial warrant, do not consent. Say, "I do not consent to you entering my home. Please leave your contact information." Step 5. If they keep asking questions, say, "I am exercising my right to remain silent. I want to speak with a lawyer." That is it. Short, calm, repeatable. Here is the part most people miss. Do not get pulled into a conversation. Officers may ask, "Is so-and-so here? How many people live here? Where were you born? What is your status? Do you have papers?" The safest approach is to not answer those questions at the door. You can repeat, "I am exercising my right to remain silent. I want to speak with a lawyer." Now, what if they say, "We just need you to step outside"? This is a critical moment. If you step outside, the legal situation can change quickly. Outside the home, the rules about detentions and questioning can be different, and you may lose the protection that comes with being inside. If you choose to communicate, do it through the door. If you feel you must step outside for safety reasons, be aware you are changing the playing field. If you are watching this because you are making a family plan, this is a big item to discuss with a qualified attorney for your specific risk factors. Example scenario number 1. Composite example. Maria is a U.S. citizen. Her husband is undocumented. They live with her mother, who is a green card holder. One morning, there is a loud knock. The mother, nervous, opens the door wide. Officers step forward and say they are looking for someone with a similar name who used to live there. Because the door is open and the conversation is happening inside the threshold, they start asking everyone questions. Maria gets scared and starts explaining her husband's story, his work, his entry, and where his documents are kept. In under a minute, the officers have information they did not have before, and the family is panicking. What should have happened instead? Whoever answers keeps the door closed, asks for a judicial warrant, and does not answer questions beyond identification and the warrant. If the officers do not have a judge-signed warrant authorizing entry, the family does not consent. If officers have a valid judicial warrant, then the plan shifts to stay calm, do not interfere, do not lie, and immediately ask for legal counsel. Now let us talk about traffic stops, because many people assume the same door rules apply. They do not. In a traffic stop, you are already in public. Police may have authority to ask for a driver's license, registration, and proof of insurance. Immigration officers might be involved in some contexts, but often it starts with local police. You should not present false documents. You should not run. You should not physically resist. But you can still use key rights. You can ask if you are free to go, and you can decline consent to search your vehicle in many situations. A simple traffic stop script. Officer, am I being detained or am I free to go? I do not consent to a search. I am exercising my right to remain silent. I want to speak to a lawyer. Notice what is not in that script. Long explanations. The more you talk, the more you risk accidental inconsistencies. Next, workplaces. Workplace enforcement can look very different from a home visit. It can involve audits, like I-9 employment eligibility verification processes, notices to the employer, or site visits in certain visa categories. It can also involve targeted enforcement against specific individuals. For workers, the biggest mistakes are assuming the employer will protect you, signing papers you do not understand, or presenting documents that are not yours. For employers, the biggest mistakes are overreacting and firing people based on rumors, refusing to follow lawful requests, or failing to follow the proper audit process. If you are a worker, safe steps include: keep copies of your own immigration paperwork in a safe place. Know the name and phone number of a trusted contact, and do not sign anything you do not understand. If you are an employer, safe steps include: have a plan for receiving government notices, know who your counsel is, and train managers not to panic or discriminate. Now we get to the one mistake that causes the most damage in the first 60 seconds. It is consent. Consent to entry, consent to search, consent to conversation that becomes a statement. Many people think they are being cooperative by saying, "Sure, come in," or "Let me just get my documents," or "Yes, you can look around." But if officers are relying on your consent instead of a judge-signed warrant, you just gave them what they needed. Here is a quick, do this, avoid this checklist you can save. Do this. Keep the door closed and speak through it. Ask, do you have a judicial warrant signed by a judge? Ask them to show it at the window or slide it under the door. Say clearly, I do not consent to entry. I do not consent to a search. Use one sentence on repeat. I am exercising my right to remain silent. I want to speak with a lawyer. If you have children, teach them. Do not open the door for anyone. Get an adult. Keep a family contact list on paper, not only on a phone. Avoid this. Avoid opening the door just to talk. Avoid stepping outside just because you are told to. Avoid answering questions about where someone is, where you were born, your status, or your travel history. Avoid showing documents through fear or confusion unless you choose to and understand why. Avoid signing anything on the spot. Avoid lying. If you speak, do not guess. Do not make up details. Here is another bridge hook. Respectful refusal is not hostility. You can say sir or ma'am. You can keep your voice low, and you can still say no. Now, you might be asking, what about green card holders and citizens? Do they need to worry about this at all? Yes, but for different reasons. If you are a green card holder, you still have constitutional rights, but you also have immigration consequences that can be triggered by certain arrests, certain admissions, or certain paperwork. If you are a U.S. citizen, you cannot be deported, but you can still get swept into a chaotic situation, and your home can still be searched if you consent, or if officers have a judicial warrant. Also, many citizen spouses accidentally harm a loved one's case by oversharing at the door. Myth versus reality number 3. Myth. If you are a U.S. citizen, you should show your passport and explain everything to end it quickly. Reality. Showing proof of citizenship may help in some contexts, but long explanations can create new problems. And citizenship does not automatically stop questioning or a search if you consented. The safer approach is, verify the warrant, do not consent to entry without a judicial warrant, and keep statements minimal. Let us talk about verifying information, because 2026 is filled with fast-moving headlines. If you see a claim like urgent federal order changed your rights, ask 3 questions. Who issued it? Where is it published? And does it change law or just guidance? The safest sources to monitor are official agency websites and official court dockets for major cases. plus reputable legal aid organizations that post Know Your Rights updates. If someone on social media cannot link to an official source, treat it as unverified. Now, what should you prepare tonight, even if you think you are low risk? Build a family safety plan, not a panic plan, a calm plan. 1. Pick one emergency contact outside your home. Everyone memorizes that number. 2. Write down key info, full legal names, A numbers if any, dates of birth, and current addresses. Keep it in a safe place. 3. Keep copies of important documents where a trusted person can access them. Passports, green cards, EADs, I-94s, receipt notices, court notices. Do not carry originals unless needed. 4. Decide who can pick up children and ensure schools have the right authorized contacts. 5. If you have medications or medical conditions, keep a list and prescriptions documented. Example scenario number 2. Composite example. Ahmed is an international student. He lives with 3 roommates. One roommate is undocumented and has a prior removal order. Officers come early. Another roommate, half asleep, opens the door and says, "Yes, you can come in. I think he is in the back room." That one sentence changes everything. Now officers are inside and everyone is questioned. Ahmed, scared about his visa, starts explaining his entire history, including a prior overstay years ago before he corrected status. Now Ahmed has created confusion and risk where there might not have been any. The better approach? Roommates agree in advance that nobody opens the door without checking for a judicial warrant, and nobody volunteers information about anyone else. They keep the conversation to, "Show the warrant, we do not consent, we want a lawyer." What could happen next in 2026? 3 things to watch. First, more guidance and training. When enforcement headlines happen, agencies sometimes issue internal reminders about procedures, documentation, and priorities. That may not change your legal rights, but it can change how encounters play out. Second, court decisions and local policy shifts. Courts can clarify standards around consent, entry, and evidence. Local jurisdictions may change cooperation policies, which can affect how information flows between local law enforcement and federal agencies. Third, demand surges. When fear rises, more people file paperwork, request records, or seek consultations. That can mean longer wait times. So if you are eligible for a benefit you already plan to file for, talk to a qualified attorney or accredited representative sooner rather than later, and avoid last-minute filings. One more micro-hook before we close. If officers are at your door, your goal is not to win an argument. Your goal is to avoid irreversible mistakes. Consent, signatures, and statements are the big 3. Let us recap in 5 quick bullets. 1. Your rights do not disappear because someone knocks. Stay calm. 2. Administrative warrants and judicial warrants are not the same. Ask if it is judge-signed. 3. Do not open the door unless you choose to, or they have a valid judicial warrant authorizing entry. 4. Use a simple script. I do not consent. I am exercising my right to remain silent. I want to speak with a lawyer. 5. Make a family safety plan now, so nobody has to improvise under stress. If this video helped, subscribe and turn on notifications, because when guidance shifts, the details matter and rumors spread fast. And share this with one person who lives with family or roommates, because the truth is, the best protection is preparation and one calm voice at the door.